Hello and welcome to Nasstar's webcast on general data protection regulation. Today we're going to look at some practical steps for law firms dealing with GDPR. My name is Lydia and I'm Group Marketing Manager at Nasstar, and our guest on today's webinar is Jonathan Armstrong, who is a partner at Cordery, who are legal compliance experts and also a client of Nasstar's. Hi Jonathan, how are you?
Hi Lydia, I'm good thanks, how are you?
I'm good, thank you. Thank you very much for your time today. I know this is a big subject and it's a very important one that a lot of our listeners will want to hear about. I thought perhaps we could start off with a quick introduction from you. Just tell us a little bit about yourself and Cordery as well, please.
Yeah, happy to. Yes, I'm Jonathan Armstrong. I'm obviously with Cordery, as you said. I've been working in this space probably for about 25 years now. I always feel incredibly old. And Cordery is a firm that helps all sorts of organizations, including law firms, with their compliance. And we help them with their policies and their processes to help avoid bad things happening. We help train their employees, and we also get involved when bad things do happen.
Okay, brilliant. So I expect that GDPR is a big topic that a lot of your clients are asking you about. So how about we get started with the presentation? So we're talking about all you need to know about GDPR but are too afraid to ask. Let's kick off then with the first slide on our presentation. Over to you, Jonathan.
Well, thanks very much. I think this is obviously a very difficult topic. So the general data protection regulation comes in around about 400 days' time, and that isn't a lot of time to prepare, really. I thought it's important, though, to start off with looking at where we are in terms of the background and the current landscape, particularly in areas like data security. Obviously, personal data has a value, and for many of us, most of what we do is around data, whether that's in litigation or in matrimonial cases or conveyancing. A lot of it is about data and its sensitivity. We've seen an increase in legislation that obliges us to keep data secure around the world, really, and the General Data Protection Regulation, GDPR, is just almost the latest episode of that. We've seen definitely a contrasting approach between Europe and the US. Obviously, I'm going to concentrate on the UK here, but it's important to remember that data security and data protection is very much a global game. If we have clients in other jurisdictions, we may need to observe those other laws as well. The Snowden allegations have certainly changed the game. We see much more interest from clients and their customers in how data is handled as a result. The Schrems case, there's details on our website if you're not familiar with the Schrems case, I think has had a real impact. And we're particularly seeing, and it's wrong to generalize, but the younger generation be more ready to make things like subject access requests and be more concerned about where their data is held. I think it's a myth to say that millennials, for example, don't care about their data. I think they are willing to share data more readily, but they certainly care when their data is lost or it's used against them. And as we're going to say briefly in this webinar, even though GDPR doesn't technically come in until the 25th of May next year, 2018, I think it's already a reality in some areas. We'll talk about a few of those later. But for example, the ICO's activity against Flybe and Honda a week or so ago, I think shows us that already businesses are being held to higher standards.
I was just going to say that you're talking about the difference between the UK and the EU there. I mean, what impact does Brexit have on this? I've heard a few people say, you know, because of Brexit, this may not come into place.
I think they're
Is that
crazy
true?
if they think that. Yeah, no, I
Yeah.
think, to be honest, I think they're crazy. I don't think there's a scenario in which the UK doesn't get tougher data protection laws. So if we look at the timing, obviously now Article 50 is being triggered, we know that the UK is likely to leave the EU sometime in 2019. But we also know that GDPR will apply from the 25th of May 2018. So whilst the UK is still in the EU, then obviously GDPR applies. And for UK businesses to be able to have a free flow of data with the EU, there's a number of options that the UK government has to make that happen. Either some scheme a little bit like the Privacy Shield scheme that the EU has with the US and Switzerland has with the US as a slightly separate scheme, or joining the EEA, or something called an adequacy decision where we ask the European Commission to bless our laws in the same way as they have blessed Canada, for example. And on any of those scenarios, we have to have GDPR equivalent legislation. And if we go for something for the adequacy decision option, it may even be that we have to have tougher laws than GDPR, because there is concern in the European Parliament, for example, about the Investigatory Powers Act and the perceived lack of safeguards for data. So I think Brexit at best is a red herring and could actually make the situation worse for the UK.
Sure, understood.
And in any event, as you'll see on the slide in front of you, we already have legislation that tells us that we have got to take appropriate technical and organisational measures. Obviously, for solicitors, they're subject not only to the Data Protection Act 1998, which is where this section comes from, Principle 7, but they're also subject to their own professional obligations to keep client data secure. And none of that changes with GDPR. I think GDPR just amplifies the need to take these responsibilities seriously. Now, my perception is that many solicitors' practices are understanding their security obligations, particularly in respect of sort of IT-related data. And obviously, those who use Nasstar will get bulletins of the type we've had from you today about viruses, which will help us protect client data. I do see more manual breach cases. So maybe 20% of the breaches we see at the moment are of hard copy papers, and that might be a client advisor or a solicitor going along to a meeting with a file of papers, or going along to court and leaving those papers on the bus or in the back of a taxi. So it's not always a technical answer to make data secure. And the other thing that we're seeing regulators concentrate on, and the words that you'll see on the screen are from the Dutch regulator, is that they also want organisations to test plans, to test data breach plans, just as we test fire drills. You know, we have a fire evacuation procedure in our offices, and we test it maybe once a quarter to make sure that people know what to do in an emergency. I think we're starting to see that as good practice under the existing legislation in terms of what people have to do to prepare for a security breach, for example.
That's interesting, because I think a lot of people do think that it's just cybercrime that people are hit with, and I think because the focus is so much on that, like you say, there is still examples of physical copies of data going missing in the way that you just described. And I think because people are focusing so much on cyber, that sometimes they can forget the basics with, like you say, leaving something on the train or things like that. So that's quite interesting.
Yeah, and a lot of simple mistakes are made. You know, the ICO had a blog this week about cases involving filing cabinets going to second-hand shops with files still in them. There's a case about a local authority that moves officers and doesn't empty the filing room. So historical cases, child protection cases, etc., are still in that filing room. And when the new occupier moves in, they're puzzled by all these files still being there. And often in an organization, I think these mistakes happen because everyone assumes it's everyone else's job to empty the filing cabinet or empty the filing room. And I think solicitors firms particularly have to make sure that it's everybody's job rather than no one's.
It's quite unbelievable, isn't it, really? But as you say, it has happened.
Yes, it has, yeah. And so, if it helps, the new rules, I think, don't change those basic principles, but they make the consequences greater. So in terms of what the new legislation does, the aims, if you like, are firstly that it's a proposed regulation and not a directive. And without being too technical, this means that the aim was that the law would be harmonized across the EU. Now, I think that's probably something that might not be delivered, unfortunately. Already countries like Germany are trying to sort of supercharge GDPR and add their own little bits to it, and there are quite a lot of carve-outs, particularly in areas like how we handle children's data. But that at least is a laudable aim. The second and third points on the slide I can probably take together. The whole idea is that we have this process called data protection by design or data protection by default, which means that we try and design in protections whenever we're doing anything new. And we do that mostly by something called data protection impact assessments. So if we've got a new idea, then we have to check the data protection downsides, if you like, and how we can improve them. So let's say, for example, I'm a conveyancing practice, and I think it's a really good idea to make the entire conveyancing case file open to my clients. So that might be a great idea, but we'd need to do a data protection impact assessment. We'd obviously need to look at things like there might be personal data of the vendors of the house, which would then be exposed to the purchasers, and we'd need to look at whether that was a real risk, and if so, if we could minimize that risk by only making certain parts of the file available, or telling our conveyancing executives to mask personal data, or whatever that might be in terms of remedial measures. And we've got to do that almost like a business case. What am I trying to achieve? What's the harm? How do I fix the harm? The next point is that suppliers outside of the EU are in scope. That doesn't matter that much to solicitors' practices, except obviously to say that if we outsource things, we use, I don't know, PeopleSoft to manage HR, then that might have an impact with us as well. We've got toughened enforcement bodies, the possibility of audits and dawn raids, and I think that's a realistic possibility, particularly if we look at the experience in some other jurisdictions and, for example, the ICO's experience with these powers that they've had in relation to NHS trusts. Breach reporting in 72 hours, I think, is a big area of concern for people. So in my earlier example, if I lose a client file in the back of a taxi, I'm almost certainly going to have to tell the ICO within 72 hours if I can't get that file back or if the data is exposed. And I may have to tell the clients, the third parties, the other people we're litigating with, the other side of the transaction or whatever, if their data has been exposed. So the breach reporting is a key thing to get right. And for most solicitors' practices, you will need a data breach plan to make sure that everybody knows what to do when they lose files, and you'll also need to rehearse that plan, as I've said, like the Dutch regulator has suggested. Next, the distinction between data processors and data controllers diminishes. I think for law firms that's always been a quite tricky distinction. Some of you will know that the Information Commissioner has already issued guidance notes to solicitors on effectively saying that you're usually a data controller. So you're usually responsible for the data that you hold, even though the file technically belongs to the client. In some cases, we'll have to appoint data protection officers who will have a statutory list of things that they have to be involved with, like training, like data protection impact assessments. And another change or an aim of the rules is to simplify transfers to third countries, so they're countries outside of the EEA. And it's trying to do that by legitimizing something that already exists called binding corporate rules. And some solicitors' practices have gone through the BCR process already and have got the ICO to bless their data handling, which should make it easier for them to transfer data around the world.
Sorry, Jonathan. I was just going to ask. So you say about employing a data protection officer. Do you think is that somebody that you already have within your firm that is trained in order to do that, or do you think that's you going out and actually recruiting somebody for that role, or does it depend on the situation?
I think it's hard to recruit people at the moment. There is a lack of talent in this space, and some of the people that are making themselves available as data protection officers might not be the best choice, particularly for a profession like the solicitor's profession that has its own quirks. So I think for most organizations, it's likely to be an internal hire. But you need to think through carefully who that should be. We have had, Germany has similar provisions already, and we've had a German ruling recently which disqualifies some of the obvious candidates. So it might not be possible to have a DPO that comes from IT or from HR, which for many organizations would be the person who springs to mind. So it's not easy to decide who the DPO should be. I sort of said tongue-in-cheek earlier to a client this week that the DPO is normally the person who doesn't turn up for the GDPR kickoff meeting. But I don't know if there's a hard and fast rule as to how people are selecting DPOs. I think it's always a good idea that you have somebody responsible for data protection. In a law firm, it might well be the COLP, subject to those conflicts, of course, between his or her responsibility as a COLP and the data protection responsibilities. But as we'll say later, I think there's some tie-in between the duties that a COLP's under the SRA rules and a data protection officer's responsibility under GDPR.
Okay, great, thank you.
So maybe we'll look at some perceived benefits of the new regulation. I have to say that I don't personally see many of these as benefits, but originally when the proposals were made, this was meant to be a balance between extra responsibilities for organizations, but also a reduction of some of their red tape. As I say, I'm not convinced that any of this will lead to a reduction in red tape or only minor benefits, but it's my job obviously to work with the law we have. It's now too late to change it. So the first one, which might be a benefit, is that there's no general registration requirement. So those of us who pay usually £35 a year to the ICO every year to renew our data protection registrations are unlikely to have to do that after the 25th of May 2018. Here Brexit could be relevant because the UK could decide to reintroduce the registration fee after Brexit to make some money for the ICO, but as things stand on the 25th of May 2018, you won't have to pay your £35, you won't have to renew. But you might have to register DPIAs. So whenever you're doing something that deals with data, you might have to register that separately. And again, we'll await guidance on how that looks in reality. There is an obligation to consult, and in some jurisdictions like France, that obligation to consult is effectively a registration requirement per process by a different name. So one of the other perceived benefits is this thing called the one-stop shop. And the idea here is that if I'm a law firm, let's say I operate in Hamburg, in France, and I have 3 offices in London, then the theory at least is that the UK becomes my regulator if I have more people in the UK than in the other 2 offices. And if a complaint is made about me in Germany or in France, that's passed to the UK regulator to deal with. So that's all well and good as a theory. In practice, I'm not sure it will work like that for various reasons that are probably too complicated to explain, one of which, of course, is Brexit, which will be a complication here. So the one-stop shop might help, but as I say, the devil will be in the detail. Consent is another area where I think GDPR does change things. Again, many of you will have seen the ICO actions against Flybe and Honda, which are a taste of things to come, I think, in terms of consent. Obviously, the ICOs had a wide-ranging campaign against charities, which is another illustration of that. And other regulators like the Advertising Standards Authority have had campaigns about consent, for example, in the recent Land's End case. It's always tricky to get consent from employees. That's particularly tricky in mainland Europe, and it's becoming more challenging in the UK as well. And if we're trying to get consent from clients, then we're going to have to be much more detailed in terms of what they're consenting to. That maybe has to be in our client care letters and in our terms of engagement, so that there's clarity over how we're going to use people's data. Bear in mind the fact that we're also seeing things like right to be forgotten requests, again, levied against law firms. So there's an interesting case, for example, involving some Russian oligarchs with an investigation into those oligarchs. And again, consent and the right to be forgotten will work hand in hand in these cases. And the right to be forgotten, sometimes called the right to erasure, it's basically somebody sending a request to say, I know you've got details on me, please destroy them. And as I say, we do see that in litigation and in internal investigations already. Then, Lydia, the next thing I think to think about on the list is the right to data portability. So, for example, I could have 10 clients and I might be dealing with, let's say, asbestosis claims for them. They could decide that they want to move to another law firm, and they can either do things the conventional way, asking for their files to be transferred to the law firm concerned, or they can, from May 2018, exercise what's called a data portability request. So say, actually, we don't want hard copy files, we want them in a common exportable format so that our new law firm can get those details onto its system much more quickly. So data portability rights, I think, potentially have an impact on the legal profession. And again, we've a new guidance note, just brand new from the regulators, which explains more about how that will happen in practice. We've also got new guidance on the right to object to profiling. This will hit insurers, for example, those who handle insurance law, because there are issues about the way in which policies are calculated. It might also hit those who are dealing with things like pensions or healthcare. And again, it's one of these new rights where we not only have to deal with requests from people who want to object to profiling, but we also have to advise them of these rights up front. And then finally, in the perceived benefit, there's an enhanced subject access request regime, sometimes called SARs or DSARs. So these are requests that people can make under the existing law. So I can write to a law firm and say, I think you are acting for my wife in a divorce, please give me the data that you have on me. Now, there are exceptions to fulfilling an SAR, and it may be that the law firm can write back and say an exception applies, we don't have to give you the details, but it may be that they have to tell the individual concerned that, or give them access to the data that they hold on that individual. SARs are relatively rare at the moment. Most of our clients see 4 or 5 a year. I think the volume is definitely increasing in the last 2 years or so. They're getting much more complex to deal with, particularly, for example, where somebody is unhappy with their law firm and then want details of exactly the emails that were exchanged between fee earners at the firm or whatever. So we're seeing more and more SARs, and currently you can charge a £10 fee. That puts off about 50% of the requests that we see, but the ability to request a fee goes from May 2018, and we're likely to see much more SARs as a result.
Okay, great. So I suppose next we need to talk about the consequences for if you're found to not be compliant, and I think there's quite a few from this slide that's next.
Yes, there are. There's more to do for controllers and processors. As I say, that's not something that lawyers need worry about too much because they're usually controllers, not processors. There is a possibility of heavier liability and compensation for material or non-material damage. We've already seen some cases in the UK which have sort of extended the right of individuals to claim when data has been handled or mishandled against them. For example, there's a recent case against the police where they arrested somebody on child pornography charges, having got his IP address mistaken with somebody else's. So civil actions, I think we can't rule out. And there are some class action funders around who are seeing this as a new market. The regulators also can levy fines of up to 4% of global annual turnover or 20 million euros, whichever is the lesser. And I think that's likely to hit law firms, particularly if we make a mistake and our client comes under investigation. Because whilst our turnover might be relatively small, then 4% of our client's turnover might be great. So to give you an example, a client of ours provides software to banks. Its position currently is that they don't cap their liability because their liability is only £500,000 and they insure that £500,000. So they've gone to market with the proposition that we are the firm that don't cap our liability. Now, under GDPR, their liability to one of their clients, we calculated, is now 2 billion with a B US dollars. Obviously, they've gone along to their insurers and said, Mr. Insurer, can you insure this $2 billion risk? And will it be the same premium as the £500,000 risk? And the insurers, you won't be surprised to hear, have laughed at them and said you can't be insured under any circumstances for that level of harm. So the challenge for our client then is, do they go back to the market and say, we said that we would never cap liability? Well, actually now we are. Or do they decide that they're happy to proceed with that level of liability without any insurance policy in place? That's a very difficult decision. And I think some lawyers are going to be in that same position as well. Obviously, we know that under the SRA rules, you are allowed to introduce caps. And I think more law firms will be looking at issues like caps as a result, wherever they're handling personal data, particularly the personal data that belongs to their clients. So then another consequence will be the possibility of shared investigations across the EU. As I've said earlier, I doubt that the one-stop shop system will work well in practice, and it could be that we'll have investigations shared. In my earlier example, if we've got an office in Germany and France and the UK, it might be that all three regulators will do the investigation jointly. We're already seeing that. For example, Google had an investigation with simultaneous or near simultaneous fines in Holland, France and Spain. So this tag teaming amongst regulators can't be ruled out. Obviously, greater reputational risk. We're already seeing that in the law firm environment. So we know of cases that you'll have read about in the press of barristers being fined by the ICO, of solicitors being fined by the ICO and by the SRA, and obviously their reputation is, if not destroyed, then at least put to detriment as a result. And we're seeing more shareholder or investor engagement. Again, something that isn't likely to apply to a lot of law firms, but something that their clients will have uppermost in their mind when they're choosing and engaging law firms. So if you're the law firm who's known for having a data breach, I think it will be business limiting, particularly if you're dealing with publicly listed clients.
Definitely. That's a big one to watch out for, isn't it?
It is, I'm sure. So the other thing to mention, perhaps, Lydia, is obviously all of this also ties in with your professional obligations. So we know that the ICO are particularly interested in data breaches amongst professionals, and as I've said, there are cases against both solicitors and barristers. Bear in mind that the SRA may also need to be notified if you have a breach, and so as a result, as a minimum, your COLP should be part of your data breach team, and you should have a team, and as I've said, you should rehearse, and that'll obviously include people from different parts of the business that'll be able to ascertain how damaging a breach is and how you can contain it. And it might be that you also need to tell the SRA within 72 hours, because if you're going to have to tell the ICO, you probably will want to tell the SRA before they read about it in the local or national newspapers. So as well as GDPR, there are some other pieces of legislation also scheduled for 25th of May 2018. There are new rules on cookies, there's new rules on marketing, and then there's this new thing called the NIS directive. Now here, Brexit might have a role to play in that the NIS directive might not be as aggressive as it might be, because the UK has some discretion, and some people in UK government have not been a fan of elements of the NIS directive. But it's important to know that if you're an operator of essential services or a key service provider, digital service provider, or your clients are, then you might have additional reporting obligations, and they might apply whether or not personal data is being compromised. So it's important whenever you have a breach just to decide whether you need to do something else in addition as well. So then I guess, Lydia, we're now into what should your response be, what should you do? And firstly, I think you should obviously have an action plan, take a risk-based approach. Most organizations will not be able to achieve everything in time because time is running short, and a lot of the work that we're doing is to help people prioritize what they're going to do. We've seen clients that have got 100-page reports as to the things that are wrong in their outfit that they need to fix. And obviously you're not going to do 100 pages worth of tasks in time. So for most organizations, pick 8, 9, 12 that you think you can achieve in time and get started on the priority areas. One of those is likely to be to have a proper data breach response plan. And as I've said, it's got to work a little bit like the fire evacuation plan on the back of a door in a hotel. Make it easy to understand for all of your employees and tell them what to do if they see a data breach. Invest in proper technology. Obviously, if you're with Nasstar, then many of those risks will be reduced for you with the managed platform, but make sure that you're implementing all of that properly, and make sure that you're looking in throughout the business. So proper technology might be as simple as a padlock from Poundland to put on people's briefcases. So it doesn't have to cost the earth, but look at where your risks are and see if there's a technological measure to try and prevent that. Review vendor contracts. You're going to need their help to report security breaches. Obviously, if you've got to report a breach in 72 hours, you want them to tell you in about 24 hours. Make sure that you have the right contract with them. Find vendors who know about GDPR, who are willing to host events like this to help their client base understand what the risks are. Put in place a DPIA process. Again, doesn't have to be complicated. It can be on a simple sheet of paper with risks and opportunities, but make sure that you document that. Make sure that you can produce that quickly if you get a request from a regulator or a dawn raid. Obviously, as we said there, get your documents and records ready to produce in any regulatory inspection. Factor this into your overhead. Think of a world without employee consent and tougher consent generally, particularly from clients. Make sure that all of these new rights, like the right to be forgotten, the right to erasure, the right not to be subject to profiling are all covered in your policies and procedures. Brief the board or the partners committee or however you handle these things. Look at annual reporting requirements if you're the type of organization who does that on an annual basis. Train your staff in all aspects of the law. This, in some respects, is probably the most important for a professional services firm. Obviously, we all employ a lot of intelligent people, but some of us employ people who are a little bit maverick as well, and we need to make sure that they understand the risks and are doing the best they can to prevent them. Set up and undertake regular compliance audits or reviews. Personally, I'm a fan of reviews rather than audits, but make sure that somebody is checking that you're doing things right. And I would say this, wouldn't I? Sense check your plans with specialist lawyers. I don't think it's an area for the enthusiastic amateur, and I think that the knowledge that firms like ours have gained from doing this on a daily basis helps establish priorities and helps people deal with risks. So that's, Lydia, been a very quick run through what's a very large piece of legislation. We've obviously got all sorts of resources, and I think you're going to point to a Nasstar blog as well, which has got some materials on GDPR on it as well. And I guess now it's time to ask if there are any questions.
Yeah, well, thank you very much for that, Jonathan. I think, like you say, it's a big topic and it's a lot to get through in, I suppose, 40 minutes. But I think the biggest thing that I took away from that is prioritization, because it's such a big topic. It's very hard to know where to start. And I think by looking at what you need to do and what's the most important thing and breaking that down into chunks with advice from people like you, I think that is the only way that people can actually make any progress with this. And I think the other thing to take away is that we can't be waiting until, a month before May next year. It needs to be a process that's going to start now, because it's a long process, and in order to be compliant by May next year, it's something that people really need to start thinking about now. And I think that's quite clear by the breadth of the topics that we've just been through.
So yeah, I agree with you, Lydia. It is important that we start as soon as possible. We saw a small professional services firm last week, for example, that has some 3,500 contracts in place with vendors and people who provide things to them. They're a relatively small organization, and many of us these days use suppliers for all sorts of different things. We might outsource our IT, we might rent premises, we might have shared services, we might outsource cleaning. And not only do we have to prepare for GDPR, but we also have to make sure our suppliers are preparing as well. So that's one of the reasons I think that we have to start now. And I think you're right about prioritization, definitely. Maybe 50% of the projects that we're involved with now are projects that have got bogged down because people don't know where to start. They know that they have to do so many things, and you do have to focus. You do have to look at the priority areas, which are obviously going to be around client consent. How do I deal with subject access requests? How do I deal with security breaches? Because they're the things that are likely to cause you the most pain if you get them wrong.
Absolutely, absolutely. So as I said, we've covered a lot today. So this webcast will be published on Nasstar's blog. So if you want to have a look at that, it's at www.blog.nasstar.com. We'll be featuring this on demand, so you can listen to it again with a short article to go alongside it to cover the key facts again that we've been through today, and some of the issues that we think you need to be aware of today in order to tackle GDPR and its implications for May next year. So if anybody's got any questions, I'm sure there will be because it's such a huge topic. Jonathan's details are on the screen at the moment. We'll also be sharing Nasstar's details if you've got any questions about the more technical side of GDPR. For example, what we can do in the background to help automate the process of gathering consent, data cleansing, or integration of systems to try and streamline the process of getting ready for GDPR next year. So if you would like to get in touch with us, and go to our website, which is www.nasstar.com, or you can give us a call on the number on the screen at the moment, and our professional services team will be more than happy to help. But thank you very much for that, Jonathan. That was really helpful. That was really good. I think, as I say, the biggest thing that I'm taking away from this now is that businesses really need to be starting to think about it now and getting a plan in place and getting the advice that they need in order to be ready for next year. So thank you very much for your time.
My pleasure.
Great. Thank you to everybody for watching. If you want to follow us on Twitter as well, we can show more information of future webcasts that are coming up. Our Twitter handle is just @Nasstar. So have a look if you're interested in seeing any more of our webcasts. But thank you again, Jonathan. We'll speak to you soon. Thank you.
Pleasure. Bye now.